I'm starting this YouTube channel, and a year ago I posted a review of Mama Bear Forms, which is a legal document drafting application that Dave Ramsey recommends. And I've got like 3,000 people have watched that video. And yesterday, a guy posted something kind of snotty, kind of mean. It's funny how if it's social media, you'll just say things, right? But a year ago, a guy asked me a question, and as you all know, I had a busy year last year, and so I feel bad that I didn't get a chance to answer his question, and I'm actually going to CC this video if I post it on YouTube to him and apologize. Here's the answer to your question, and what he said was, why do I even? I'm paraphrasing, but why do I even need a last will and testament with all these transfer on death beneficiary designation forms that are available, right? Well, he's could be correct. Like that's a good point. If his goal is estate transfer as compared to asset protection, like that's the big distinction. Now, once again, I believe, and my message is, estate transfer has very little value to you. Let me repeat that. It's not your fault. You've just been inundated with marketing messaging, usually from the financial services industry, because that's all they can comprehend. But estate transfer, estate planning equals estate transfer. And here's the way it works. The word estate in the law means you're dead. Like that's the whole, until you pass away, there's no estate. And so estate is actually the holding area, the legal construct, what the law calls assets of a dead asset owner. I'll repeat that. An estate is the assets of a dead asset owner, because the golden rule of estate planning is you cannot take it with you. What that means is when you pass away, you leave everything that you've accumulated behind. Now, America is obsessed with title, like who owns it. You know, there's like litigation about who owns what. But essentially, there's a lot of all property, except for tangible personal property, has title. And remember, there's two broad categories of property. We've gone over this before. It's worth repeating. Real property and personal property. Real property has two subcategories: real estate and real property. And real property is legal interest that attaches to real estate. Real estate is dirt. Real estate is the actual land, the raw land, the parcel, the easement that goes over it, the covenants that associate with it, all of those things, air rights, mineral rights, that's all real property. Real estate is dirt. Real property is legal interests that attach to it. Now, the other type of property is personal property. There are two kinds: tangible, like this, something that's present in the physical world, I can touch it, and intangible. Now this person's question is dealing with intangible personal property. So his question was, why do I need a will at all if I can just go to my Schwab account, fill out the transfer on death beneficiary designation form, right? And when I pass away, that account will vest title in the beneficiary, my surviving spouse, one of my kids, a charity, whomever I choose. And he's absolutely 100% correct about that. And so if we look at this graph, I just took this from, made it quickly, so there's not a lot to it, but it shows the three types of transfers, the three broad categories, the three ways property transfers when the asset owner dies. One way is the archaic way, and that's probate, with a last will and testament. Now, probate comes from the Latin word probo, probare, which means to prove, to clear title. I mean, it's all about, okay, this parcel belonged to Daryl. He's dead. Who does it belong to now? Now, a last will and testament, once again, dating back to 1066, that's when the modern way of transferring property was first originated way back then. A will in the medieval times was a written document that transfers land, real estate. A testament was a written piece of paper that transferred personal property. And so the law said, okay, let's just combine, like modern law, like let's combine it, last will and testament. So it's a legal document presented to a court in which a personal representative or an executor or an executrix is appointed to transfer title once all the bills have been paid, once all the taxes have been paid, once all the court fees have been paid, when everything's paid, then the personal representative has authority to transfer title of all the probate assets to the beneficiary, right? The heirs, actually. The next way property titles is operational law. And that's just like my broad way of saying it. And it's kind of like all those miscellaneous things. So we can transfer into a living trust property. And the way living trusts work is, okay, look, I don't want to go to a probate because that's a court procedure and I'm afraid of court and I don't want to pay any fees. And so what I can do is all the property that I want to give to my family before I die, I can transfer into a trust. And I can be the trust maker during my lifetime. I can be the trustee during my lifetime, and I can even be the beneficiary during my lifetime. Now, we have talked about asset protection as compared to estate transfer over and over and over again. The distinction is this. Asset protection is about retitling assets during your lifetime so that a creditor cannot reach that asset. It's also positioning wealth when you die in trust so that creditors of the beneficiaries cannot reach the asset. In particular, Medicaid, tax agencies in some case. Like when we create a credit shelter trust that avoids unnecessary estate tax, really what we've done is we've used an authorized trust to double our credit amount. But for that trust, we would pay estate tax in many cases. The law does not. The law actually has this gift of saying, like, look, you can use a credit shelter trust, double your credit amount, and avoid $160,000 in estate tax. That is asset protection, right? Now, while you're alive, you can transfer wealth into like a Medicaid asset protection trust, and that asset is preserved. Now, a living trust offers no asset protection, none, zero. The only thing a living trust does is estate transfer. And so the concept being, okay, so Daryl transferred property into, let's say his home, into the living trust. Daryl's dead. However, under probate law, there's not a problem with title because even though Daryl is dead, technically the trust owned the asset, not Daryl. Therefore, title is good. The only thing that needs to happen is the designated trustee comes in, which would probably be my oldest or my son. He steps in as a trustee, then he can pay all the bills, liquidate the home, and then pay it out to the beneficiaries, which would be himself and his sister. I have 2 kids. Now, that is a transaction that does not require probate at all. The last way, sometimes, like if you think about a life insurance policy, that's in that category actually, because a life insurance policy is a contract. You deposit money into the account, make premiums, either a term or whole life policy. When you pass away, the life insurance policy pays to the beneficiary. It's kind of like a living trust. It's like by contract or by nuances in probate law, we do not have to get permission from a judge to transfer assets and retitle them into the name of the qualified heir. Now, concede that a living trust doesn't do me any good. Like I create the living trust. I transfer my property into the living trust. And it is a way to have like living trusts have a purpose, but it's an estate transfer purpose. I have to die, I'm dead, and then the living heirs receive the asset without a probate, without stress, right? That does have value, but it doesn't really benefit me during my lifetime because if I get sick, let's say I'm single, which I am, and develop dementia, a living trust is not going to help at all. like it is an available asset. In Ohio, in Washington state, and probably some other states by now, any property in a living trust is not considered an exempt asset and must be spent down before Medicaid offers any benefits. If the personal residence had been left out of the living trust, right, and I needed Medicaid, the personal residence would be exempt, would not count as an asset, would not be subject to spend down. If you transfer it into a living trust, it is now non-exempt in Washington, and probably some other states, is non-exempt and technically would be need to be spent down or transferred out of the living trust. And so in that case, it's a great example of, okay, oh, we want to avoid probate at death and we want to get assets to the heirs as quickly as we can. Well, you just shot yourself in the foot because now you've rendered an asset that was exempt to a non-exempt status. Now, this person's question focused on TOD, which means transfer on death. And that's really operation of law. But what happened was the financial services industry kind of hijacked estate planning. And in order to make life convenient for them, I don't even know how it happened, but over the years, it became lawful to create an account, have some rules about the account, have an agreement about the account, and then either think of it as joint tenancy with right of survivorship, tenancy in the entirety, tenants in common, does not matter, but designate who the account will go to on your death, right? And so if you think about a retirement account, you have a primary beneficiary and secondary beneficiary. When you pass away, if you name your spouse as the beneficiary of the account, well, then she automatically inherits it. Like she has the retirement account. If it's a brokerage account, a checking account, you can just roll it over seamlessly so that that person owns the account. Now, if your goal is estate transfer, like I'm dead, I don't care, I'm just going to give it all to this person, surviving spouse, kids, or charity. That is a great way to do it. Some states, for the YouTube video, I'll put a list of the states. I don't have them right off the top of my head, but many states have transfer on death deeds. Remember, real estate can only transfer by deed. That's it. And so in a probate, a personal representative is appointed if there's real estate of any kind, personal residence, recreational property, commercial property. The personal representative has the authority to record what's called a personal representative deed, meaning, hey, I want the personal residence to go outright to my wife. Well, personal representative will just record a new deed that says Daryl's spouse owns it 100%, but it has to be by deed. Many states now have transfer on death deeds, which is a deed that you record while you are alive. It's very bizarre. While you're alive, you record this deed that says, look, I want my son to own my personal residence, but not now, only when I pass away. And so it's just there giving notice to the world that this thing is going to happen upon death. And then son can just present a death certificate and then new title will vest in his name. That's great because we avoided probate, right? Like we didn't even have to have a last will and testament because all we owned was a checking account and the personal residence, a home. That's it. Those two assets. Well, the checking account can vest with the third category, transfer on death. I just have to fill out a beneficiary designation form. Just like the beneficiary designation form, we can do a transfer on death deed, so title automatically vests. Now, y'all that are on this call, please open up your mics because I'm going to ask Karen. I'm going to ask first Karen. No, she panicked. I saw panic in her eyes. Okay, I'm going to ask Susan. Susan, tell our listening audience what is the major flaw in transferring everything automatically at death to the surviving spouse?
You could be subject to state tax.
True. What else?
I don't know.
How many times have we talked about spousal protection trust?
Oh, yeah.
See, I like it because what that means is like, well, you're like, well, yeah, of course. I mean, I think it's just become like so ingrained in you. Okay, Shannon's new to the club. Have you heard me talk yet, Shannon, about spousal protection trust?
Yeah, the first thing that comes to mind in that situation would be then that opens up your spouse to be subject to medical bills, Medicare, where that spouse now will have to spend everything down.
I feel like I wish I had a sound effect of ding, 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 ding. You know, that game show when you get the answer right thing. Like that's exactly right. This person that asked this question might be single, right? And so you're not going to worry about a spousal protection trust if you're single. However, if you're married, you need to understand that sometimes automatically vesting title in the surviving spouse is the biggest mistake you will ever make. Because as soon as it vests in her name, I mean, like statistically, women outlive men. And therefore, most of the long-term care services are being provided to women, to widows. 70% of all nursing home residents are female. I think that statistic is soft. That's the last one I read was 70%. Every time I've gone to a skilled nursing facility, it seemed like more like 90%. 2/3 of Alzheimer's patients are female. The silver tsunami is kind of what we use to describe the fact that the baby boom generation and some of the X-Gen guys now are all aging at the same time. And so they're like, there's this big demand for long-term care services, but it's not gender neutral. It's gender biased. Most people who, and statistically, when I think it's like a 40% pay cut. So when husband dies, women suffer a 40% decrease in monthly income, something to that effect. And then once they fall and break a hip or get sick or just become to the point where they just need help because of age, now they're paying $5,000, $6,000, $7,000, $8,000, $9,000, $10,000 a month in care costs. That can only go on for so long. Now, federal law has a great, not total solution, but a great resource, it's like a gift. And here's the way it works. Federal law says, look, husband does not have to give everything to wife outright, because if she does, it's subject to Medicaid spend down, 5-year look back period, transfer penalties. Rather, you can transfer the inheritance of the wife into a 42 USC trust, this very specific trust, and the assets inside of the trust are protected against creditors for the spouse, to include Medicaid. That trust, the assets in that trust are specifically made for Medicaid. That trust, that's what it does. Now, unfortunately, I don't even think it's a disadvantage, but people have been so ingrained with avoid probate, avoid probate, avoid probate. Well, probate is required because that trust has to be created by a last will and testament. That's just what Congress said. We don't get to argue with that. It has to be in a will. You have to have a will. It has to go through probate. If you do, the gift is the single best asset protection trust in American jurisprudence. 5-year look back period does not, like, it's the only way you can make a transfer without a penalty and after death is with this trust to avoid Medicaid spend down. That's the only way. Just follow that rule. Put a spousal protection trust in your last will and testament. Understand that you're going to go through probate and get away from this concept of avoiding probate with transfer on death deeds, because you may not want it to vest automatically in the name of the beneficiary. Now, that's also true for kids. Sometimes my clients, like when my clients have wealth, they're like, I'm not sure I want to give my kid $500,000 outright or $2 million outright or whatever. I mean, I love my kids, but I worked hard for it. And I know my kids, man, the Audi dealership's going to make out like a bandito the day after they get their money. And so when you do a transfer on death transfer, you're just saying, here, go. You might as well just name the Audi dealership. It's like, look, Anyway, you see my point. It's the only way to create a trust. Yeah, it's called a dynasty trust. So even if we're transferring to the second generation, oftentimes we want to create a trust. Now you can do that in a living trust, but with the benefit of the Spousal Protection Trust, you should just put it in a will. Otherwise, you're just giving all your wealth away with no strings attached, no anything. Another thing about transfer on death deeds, you're asking for trouble. I think you're asking for trouble on a transfer on death deed because, like, just imagine I want my cabin in the woods to go to my 4 children. So I'm going to get an executed deed. Title's going to vest in their name. So guess what happens when I die? My 4 kids are equal tenants, have an equal share in the cabin in the, and like I had no rules about it, did I? I didn't say every other month, like on rotating monthly basis, you can go to the cabin. So what happens is one weekend, all 4 kids show up with all their kids. There's just conflict. One kid is in Alabama, the other 3 kids are in Washington. The kid in Alabama never gets to go to the cabin because they live so far away. So he resents the fact that the 3 other kids are joining the cabin in the woods. So what does he want? He wants to be cashed out. And then they say, that's not what Dad said, you're stuck. Then the guy in Alabama dies and he has 8 kids. 3 of them moved to Washington. And now you've got, how many, that would be 3 plus 8, now you've got 10, 11, 12, 13, 14. As the original kids die and leave it to their family, you might have 23 tenants of this cabin, and it just doesn't work. A better way to do it would be to transfer it into a testamentary trust that says, look, here's the rules, or just cash it out completely and give the kids cash. But you can't do that with the transfer on death deed. The transfer on death deed just vests title equally, or however you want to structure it, but probably equally. And for the most part, you're almost begging for a problem with the family by doing it that way. Now, there are times where it works and it works well. If you're single and there's one heir, and you want the family that to work, like you can't do a spousal protection trust if you're single. So really, my message about spousal protection trust, that is the one thing that married couples need, period. Unless you're super, super high net worth. But even a $2 million estate can be ravaged by long-term care costs. Concede that. If you're single, well, you could do a transfer on death deed. It depends on the family. You can even use a transfer on death deed to bypass a spouse. So just imagine second spouse, like second wife, your kids are from the first marriage. You've got a cabin in Arizona, got the family residence that you and your wife live in Washington. You set up a spousal protection trust for spouse, but there's no reason to put the cabin in Arizona into the spousal protection trust. Like that spouse is not going to Arizona even now to enjoy the cabin. The kids grew up going to the cabin. And even though it could go in the spousal protection trust, it's just going to sit there and roll over to kids anyway. So you could bypass. You could give the assets that you want to into the spousal protection trust for the benefit of the spouse, and then use transfer on death deed to avoid probate and leave the cabin specifically to the boys, the kids in Arizona. See how that works? And so you've got these different channels, these different mechanisms. Each asset transfers in a different way. And so as you plan your estate, as you plan your retirement, you got to think, okay, look, spousal protection trust, yes, I definitely want that. It's going to have to go through probate. Are there assets that I want to channel outside of the spousal protection trust? If so, beneficiary designation form. Okay, that's it. I don't know how long I talked, about 28 minutes. Hopefully that'll be a great YouTube video. And hopefully the person that asked that question a year ago watches the video and gives me the thumbs up. Now, what are your questions?
Okay. So another instance where we use a spousal protection trust is when we have the disability part, right? Before death. Is that the same kind of trust?
No.
No.
Like there's no panacea. I love that word, panacea. There's no trust that solves all problems. Now, a spousal protection trust is created, but it springs into legal existence by a will. That's what the law says. Now, the only way a spousal protection trust can spring into existence then is if the person that made the will is dead. Like that's what a will is. It's like, look, I want to create this trust while I'm alive. I want it to be legal effective, but it does not spring into existence. It's not funded until my death. It will be for the benefit of my spouse. Now, your question, as I understood it, is, okay, Daryl, but that benefits my surviving spouse. What about me during my lifetime? Which is a much more important question. That's not your question?
My question related back to the limited power of attorney and the trust that was created by that.
Yes.
Okay.
I was just about, that was the next thing I was going to say.
Okay.
So what you're talking about is, and if anybody on YouTube watches this, Susan is talking about a nest egg trust as compared to a spousal protection trust. A nest egg trust is, in the Boom X Academy, we acknowledge that there are different kinds of Medicaid asset protection trusts. So we can, as Americans under 42 USC, we can make a transfer into a trust, and those assets will not count as assets for Medicaid purposes. There's two kinds. One, and we talk these trusts, all of these trusts are covered in the nest egg course. If you become a family leader, you're automatically enrolled in the nest egg course, and I go through them. I remember where I was because I was in Bonner. Remember, I was in Bonners Ferry, Idaho. Remember that beautiful park behind me?
Mm-hmm. Yeah.
I was, yeah. And I talk about the trust, all these different kinds of trusts. But the one that the nest egg trust is a 5-year transfer trust. And so during our lifetime, we're like, okay, look, at this point in my life, like Shannon does not need a 5-year trust, right? She's 12 years old. she's young. Anybody that's younger than 40, I always say they're 12. She's she's just young, right? Now, as you age, I mean, like I'm 58. It's getting time. Actually, I'm setting up a nest egg trust now. And what I'm doing is I'm like, okay, look, I'm single. Every day something hurts more than it did the day before. And, I'm just as mortal as the rest of y'all. But in my case too, I've got a good relationship with my son, and I want to finance his life because, he's an artist, and so and his sister. And so transfer money into this irrevocable trust, and it becomes family money. Now, I don't have any control over it anymore. But in the event that I get sick, the family has money to take care of me, right? Like you got to have a family that has those values. Now, I am taking a risk. I'm taking a risk that they don't like the old man. They just put him out on a raft, and,
And Daryl, you said you still have control over the money? You don't have control over the money. Do you pay your own bills still?
Well, that's my point. Okay, so this is a critical distinction. It has to be a nest egg. I mean, that's why I call it the nest egg course.
Oh, that's right. Okay.
Yeah, it's not pay your bills money.
I remember that. Okay.
Yeah. I mean, nest egg. I mean, like, I don't know how else to emphasize. It's just for the nest egg. And the nest egg is that pot of money that in old age, I'm not using. Like, I'm slowed down a little bit. I've got everything paid off. And my income is greater than my monthly expenses or pretty damn close. But I've got this chunk of money that is just sitting there doing nothing. And the reality is, at a certain point in my life, that money will do one of two things. It will either go to a nursing home expenses, or if I'm lucky enough just to die, like just wake up dead. If that happens to me, yay, it goes to my kids. That's the only purpose of the money. And people, I think so few people like even want to learn about a nest egg trust. They just don't believe that will happen. But statistically, if you're female over the age of 65, it's more likely than not that it will happen. And so, let's be realistic. So you make a 5-year transfer, wait out the 5-year look back period, all the money in that trust. Actually, that's not even true. The Medicaid law and regulations specifically state it's only transfers that is made for Medicaid eligibility purposes. Mm-hmm. And so if you're not even sick when you make the transfer, like I'm going to make a transfer into a trust for my grandkids' education, then a month later you fall and break a hip. Well, that transfer is not subject to penalty because it was not made for Medicaid purposes. It was made to finance grandkids' education. However, Medicaid, those guys, they'll deny the application, but you got to bring it up you'll win on appeal because they're just denying the claim without following the rules. But if you are making it for Medicaid eligibility purposes, Medicaid says 5 years. It doesn't say 6 or 7 or 8, it says 5, which implies that basically Congress is okay with you waiting out the 5-year look back period. I don't know how else to say it,
So when you make that trust, with your nest egg, what do you have to say it's for Medicaid purposes? You don't have to say it's for your grandkids' education. Do you have to say it's for something?
Well, what'll happen is a lot of people make transfer. Like you have a constitutionally protected right. I'm going to pause for just a minute. There's Puerto Rico is really loud, and so there's a bunch of music. Can you hear it?
Mm-hmm.
Yeah,
a little bit.
My door is open, so I'm going to shut it. Hold on.
I thought that was a TV.
No, they're going down the street with their big speakers blasting on the top of their trucks.
Oh, really?
Yeah, that's what he says.
Yeah, but this one is actually from the Kioscos. So I live in a town that's really poor. And there's but Puerto Ricans are very family and social community based. And so there's they're like little, it's kind of like permanent food trucks, and there's about 5 of them. One serves pizza. This is like a little small building. And there's like a little square and a gas station. Puerto Ricans drink alcohol until 2:00 in the morning at gas stations. I'm not kidding you. I don't know why. And so people will literally go to the gas station, buy beer, and then sit in chairs outside of the gas station until 2 in the morning, 3 in the morning.
That's downtown Spokane. It's okay.
Yeah. Well, there's a festival going on here. So the fiestas have just been going ape. And so they start music, live music down at the Kioscos. It's only a block and a half from here. So I actually went, I kind of avoid it because I don't know Spanish, but a buddy of mine went with me, and so he interprets for me. And then I find out that there's a blue-haired girl that has a crush on me down at the kiosk. So okay. Now there's a reason to go. Anyway, what were we talking about?
The 5-year look back. Oh, the reason.
I mean, it's astounding to me. There's some good, like one thing that bothers me is, I'm going through this right now, actually. The law says that you can use a trust can be a beneficiary of a retirement account without it triggering the non-natural person rule. We covered that last time. That video, and don't worry, it's going to be posted as a separate article on BoomX Academies, so everybody can watch that video with some additional content here next week. But we went through that for an hour, really, at last office hours. A trust can be the beneficiary of your retirement account. However, the financial services industry, financial advisors do not have any training or education. They have to take a 2-week course and pass a test. Now they're financial advisors, right? And if they're good salespeople and they're good with relationship building, they can be very influential with clients. However, they have no training or education. Like, I think that just by observation, most financial advisors that I've met used to be school teachers. Like school teachers, like they retire from school teaching and then they become financial advisors, it seems to me. I mean, I don't have any statistics on it. And so when it comes time to change the beneficiary designation of the retirement account to the specifically named trust, they come back and say, you can't do that. It's against the law, and we'll issue a 1099 at death, which means they're going to report it as a full transfer. Now, Medicaid's not that different. A lot of the social workers who take that claim just don't know the rules very well. And so when you come to that 5-year look back period, they will actually, I've had Medicaid social workers tell my clients, you cannot make a transfer. You need to give that money back. Well, I'm like, okay, I'll bite for it. I'll bite on that. If we can't make a transfer, why does Congress have a 5-year rule? And they're like, huh? Well, a 5-year rule implies you can make a transfer after 5 years, right? I mean, like, right? And they're like, well, yeah, okay, well then approve the application. Now, there's another rule that says only transfers made for Medicaid eligibility purposes invokes a penalty. Well, that implies that you can make a transfer within 5 years if it's for another reason. And a great argument to support your argument that a penalty does not incur is because you weren't even sick. Like, it's like the judge would sit there and go, well, you did that for eligibility. No, I didn't. I was perfectly healthy when I made that transfer. I mean, I'm not that. I mean, I can see there's a possibility I could get sick, but isn't that true of everybody? I made it for family planning purposes. You cannot penalize me for that. That's what the law says. But people don't know that, and Medicaid officers don't know that. So you if you're admitting a transfer within 5 years and asking and arguing against a penalty, you're going to have to do that in an administrative hearing. So you just appeal it, and a couple of months later, you have a hearing in front of a judge, and usually you'll win. So, and in VA benefit law and Medicaid benefit law, it's appeal until you win. Like, you got to know the rules, you got to be right, but eventually you'll win. Now, you can encounter claims officers, social workers that know the rules. So, I mean, I'm not trying to disparage all of it, but, was that responsive to your question?
Yes, thank you.
5-year transfer pool. The nest egg course. The nest egg course, I think, is good. And Shannon, the nest egg course is actually the easiest thing that you can do, but it has some moving parts to it. And the reason I structured it the way I did is because probably you're not going to remember. Like you can learn this rule and understand the difference between estate transfer and asset protection and see the value of asset protection. But if you're young and haven't created the trust and moved money into it, probably what happens is as you age, I gotta turn this off for a minute. Can you hear that beeping? My buddy's already texting me about boating. He'll just keep up. Ding, ding, ding. What time are we going to go? So I had to turn that off. But you're going to forget, Shannon. You'll become old like I am. And pretty soon it's going to start with like you start leaving the water on the thing. I left the water on the kettle outside and burnt the hell out of my, because I forgot. I was distracted. And then I'm going to forget tort law and then property law. And then I'm going to forget that I'm supposed to make a transfer to this trust, right? And so what we did instead was say, look, where is a place that we could put our plan and our desire and our knowledge that has a higher degree of likelihood of not being lost, not being forgotten, and being followed to the letter? Power of attorney. Like there's no better place. Like that's why I object to financial services, because they think a retirement plan is a spreadsheet. It's not. Nobody gives a shit about the spreadsheet. They do care about a power of attorney because the agent has a statutory fiduciary duty to follow it. And my clients lose their legal documents all the time, but probably there's at least a better chance that you're not going to lose the power of attorney. So when mom has a stroke, hopefully son will pick up the power of attorney and say, oh, wait a second. It says right here, if mom has a stroke, create a Medicaid trust and move money into it. And here's the assets we want to move to it. That's brilliant. Like that is brilliant, because what you're doing is when you have capacity, when you have your marbles, when you have that knowledge, you're laying out exactly what the steps are to follow it. You're designating the person that has to follow it, and you're helping them by saying, look, here's the trust, here's the assets, move it. Even though you're gone. Because that's what goes wrong, man. I'm an elder law attorney, so tell me, when it goes wrong bad. So, but it's the nest egg, Shannon. It's not the money that you're using for your life. Like you still have to pay your bills. You still have to, like, if you have a budget for taking the grandkids to Disneyland every year, I guarantee you eventually you'll stop doing that. I mean, it might be fun the first couple of years, but after a while, Disneyland gets to be a pain. Going down Splash Mountain with screaming grandkids one more year is not what you're going to do. But, if you have a budget for that, that money does not go into the nest egg. The nest egg is that money that you're not using, that's just sitting there, that's really just going to pass to the next generation anyway.
Daryl, I keep coming back to probate in my mind about where probate got such a bad rap. Because I know, I don't know where it started with me, but I know in my mind, it's like, you want to avoid probate at all costs. That's why I have this in my head. But I mean, why? What is it about probate that scares people so badly?
I think it's because of financial services industry. A lot of the living trust seminars are being conducted by financial advisors. If you think about financial advisors, they really don't do anything, right? Like you give them your money and they put it in some mutual funds or something with a portfolio. They make $20,000 a year on fees or whatever. Or if they're selling an annuity, they get a big fat commission. but they have no education, no training. They don't know anything. And so what they started doing is like, oh, well, living trusts are really easy. We'll just hire some lawyer to do it for $500 because they're desperate. And then we can sell we can, like, if they meet with us to talk about the living trust, then they'll give us all their financials. And then we can magically say, oh, you might want to consider an annuity. It got so bad, Shannon, that about 10 years ago, maybe 15 years ago, time flies, man. The state of Washington passed a law against living trust mills because it was so fraudulent. But they're still out there doing it. And so they're kind of the culprits. Like they're doing these dinner things and they're railing about probate. The other thing to know about probate, Shannon, is that probate is the only way to permanently bar creditors. Like the danger of transfer on death and living trust. If just imagine, a lot of my clients are private people. Their kids have no idea what they own. No, none. And then the person becomes demented. And when they pass away, the kids have to go through this, the binders and try to find stuff. Annuities only have an annual account statement. Very easy to miss. There's $65 billion in unclaimed property in America. And it's from old people forgetting what they owned. Right. And that's the problem with like transfer on death and living trust is like, it's just, you're out there and just imagine how messy your death could be. The worst experience of my life was in Spokane. I was in a car or a bicycle accident and my face was messed up and had to have plastic surgery. You think I'm ugly now, you should have seen me. But I could have died and then there would have been all of these medical expenses out there, right? I'm in a different city. Some guy died, ambulance, heart surgery, whatever it was. And then my son steps in and it's a living trust, so there's no probate. And then he's doing the best he can. Then finally, 3 years later, the medical ambulance driver figures out I'm dead and tries to get their bill paid for $25,000. Well, my son Ben paid it all out. He doesn't have any money anymore. Well, he's personally liable for that with a living trust. He's personally liable for that if you use transfer on death designations. If you use a probate and publish in the paper, they have 4 months to respond. And if they don't, they're permanently barred forever. But have you ever heard a financial advisor say that? No, because they can't sell a living trust and get your financials with a will. The other reason it's so prevalent is because living trusts are very easy and lawyers charge $10,000 sometimes for those packages. So it's not just financial services, it's lawyers too doing that. And
so probate kind of expedites all that, right? Gets it all out in the open, knocks it all out, 4 months, and then you can move forward with the estate.
And it's closed, man. When it's closed, it's closed. Like it's settled because the law wants it to be settled. Like the law does not like questions that linger for 3 or 4 years. And so the rule is, and here's a trick. If you're on YouTube, don't listen to this, but lawyers are tricky. So the rule is 4 months probate. The rule is not 4 months of notice. It's like give notice during the 4 month time period. After 4 months, close it. And so good probate lawyers, they give notice out at the 3 month mark. And then they close it at the 4 month mark. There's like a little hiccup in the law, at least in Washington. That may not be the case in other states. But you see what I'm saying? Permanently, like big value probate is permanently barred. Another thing too is you're not really spending anymore. Like you do have to hire a probate attorney. I charge like $3,500 to $5,000 for a probate. If you're existing clients, $3,500. If you're new, $5,000. Just if it gets litigious, I'm out. Now, you still have to go through a bunch of stuff with a living trust. In fact, in some ways, it's worse because you're not doing it right. And so stuff could come up later, right? But you still have to change the title. You still have to contact the bank. You still have to record deeds. You still have to do all of those things. Why not just pay the lawyer to do it for you and have it settled for good? Now, I don't think that probate's appropriate in all cases. In fact, we share on this call, but there's one person in this call where we are avoiding probate. Like that's the strategy, is to avoid probate. There's no reason to go through a probate. However, for married people, it's like you have to have a spousal protection trust. So you have to do a probate. And don't feel bad about it. Feel good about it, because it's a good thing. But, everybody's different. Every family's different.
And probate is attached to the last will and testament, correct? So if you have a last will and testament, you are going to go through probate.
Yeah.
Okay.
Did you watch my video on the Vikings?
No, that doesn't ring a bell.
Susan's like, oh God, here we go. Okay, she hasn't heard it, Susan. I'm going to do it in 2 minutes. Okay, you can just leave the call if you're going to give me that attitude. I know what you're thinking. Okay, you tell a story if you know it so well.
No, I don't know it that well. You go right ahead. I'm mute because my little dog's having a little barky thing going here.
Yeah, the roosters are starting up out here, so.
I'm thinking about your raft comment earlier about your son putting you out on a raft. I was thinking of the Viking funerals, right?
Yeah.
He just lights you on fire and send you out there.
I thought of that too. So there was a Viking. His name was in Normandy. So Normandy is in northern France, like invasion of Normandy, right? But it means land of the Norsemen. And what happened was a guy named Rollo, a Viking, who's depicted in the movie or the History Channel show Vikings. He's one of the main characters. But the real Rollo sacked Paris, and they bought him off. They said, okay, look, if you just leave, we'll give you your own kingdom. Well, it gave him a kingdom in northern. So he brought all these Vikings there. And from about 1066, not only did William the Conqueror, who was a descendant of Rollo, cross the English Channel and conquer all of England, other people from Normandy started the Crusades. Like the first Crusades were like the ones that worked. And it was just because it was a bunch of Vikings trying to take over the Middle East, which they did all at the same time. These were amazing people. But William the Conqueror took over all of England. Well, he's French, man. He doesn't care about English Anglo-Saxon crap. So he just brought French law. And there's this concept of a logial title. I'm the king and I own everything. And what he did was he parceled out new estates. He kicked the English people out and he put his French buddies as the new lords of these estates. But he did something that had never been done in the law before. It used to be land was land and that was it. He created property interests. So he unbundled property interests. He gave the land on conditions. The condition was you kept paying fealty, you supplied troops during war, and you paid tax. And you could pass it on to a qualified male heir. Well, if you didn't have a qualified male heir, it reverted back to the king. That's how we can create trust, because we can parcel out different interests. Like that concept still exists today. Now, he had a problem, didn't he? His problem was, how do I know when an estate owner dies? If we don't have Google, I can't just, Google it. And how do I know it was a qualified male heir that got it? And so he was like, okay, well, I got to find that out. And he was so smart, he created ecclesiastical courts, which is a court inside of a church, because the local parish knows when somebody dies. Brilliant, right? And so he created a system where you had to prove that there was a death, there was a will, and a qualified heir. And they conducted jury trials every time a state owner died. And then they reported back to the crown. If it was thumbs up, title passed. If it was thumbs down, the king took it back. That's probate. It still exists today. Now, today we don't use jury trials, we use affidavit. And in Washington, it's a non-intervention state. So the court's like, just here, I'll appoint you as a personal representative, go do your thing, and then close it after 4 months. Don't bother me. That's why it's so easy in Washington. Some places, I guess it's more complicated. In Florida, there's a requirement for inventory. So you got to file an inventory. Here in Washington, we're more into privacy out here. So there's no requirement. How'd I do, Susan?
I think you left something out, but I don't know what it is.
Oh, I left a lot out. Well, the part that I find fascinating is, in fact, I don't know I got a problem, man. I love history and I spend a lot of time thinking about stuff. And I've always been interested in plagues, even before COVID broke out. And COVID is nothing, man. The Justinian plague, oh, man. Marcus Aurelius died of the the Emperor of Rome died from plague. So the bubonic plague has been around for a while, but when it broke out in the Middle Ages, oh my God, it was, you know how it spread? One army chased some folks into the city of Caucasus, which was right on the Black Sea. And the Tartous army started dying of the plague. So healthy people are on the inside and people dying army with the plague are dying on the outside. So the people inside are like, this is awesome. Well, the Tartous army was so desperate, they started catapulting corpses of plague victims into the city. They did that for 2 weeks straight. Well, of course, you know what happens. Plague broke out in the city and they were Italian merchants, basically. So they got on ships and they sailed to every port in the Mediterranean. And so it just spread all over from the plague incident there. And to me, I see the mental image of corpses flying through the air and exploding is just awesome. But the plague started killing all the estate owners, Shannon. So like if you know that you're going to lose your estate if you die and don't have a qualified male heir, and your heirs are already dead from the plague, and you have bumps on your body, you got a problem. So all this land started reverting back to the crown. And so lawyers stepped in and created the very first modern trust because of the plague. And what they did was they transferred title to their law firm because William parceled out interests. And so the lawyers held legal title. The estate owners kept beneficial title. And because of that, there was never a triggering event. There was no need for probate. It was the first probate avoidance trust. And that trust exists basically in the same form today. And it was, no kidding, a legal invention by law firms to save land for asset protection purposes against the ravages of the plague. Pretty cool, right? That's what I left out, Susan.
They use like herd immunity to get all their land back.
Yeah, but you know something, the government's always been trying to take land and the rich people have always been trying to prevent the government from taking it, right? That's why in America, well, if you think about it, the Biden administration wants to tax unrealized gain because rich people buy property and they don't sell it. They get dividends off of it. Dividends are taxed less than income. Like Warren Buffett is famous for saying his secretary paid more in taxes than he did last year. That's because all his wealth, he pays himself a low salary. Everything else is dividends. It's taxed at a lower rate. And there's no tax on unrealized gain. When he passes away, it'll get a step up on basis. You'll avoid capital gains tax at all. Warren Buffett's 92 years old. The rich pay far less in tax than the poor in America. Period. And man, that goes back to the beginning of government. Okay, it's 11:03. I talked enough. Any other questions?
Not today.
Okay, so get on YouTube and start watching videos about William the Conqueror, and we'll pick it up next week. Okay, bye.
Bye.